The summer of courtroom drama has begun. Here at home, we're in the second week of Michael McCarthy's trial. He's the man accused of murdering 2-year-old Bella Bond, formerly known as Baby Doe, after her remains washed up on Deer Island 2 years ago this month. And it took police months to identify her, too. In another high-profile local case, opening statements start tomorrow in the trial of Michelle Carter, the texting teenager accused of persuading a friend to kill himself back in 2014. And in Pennsylvania today, Bill Cosby's trial began in a case dating back to 2004, when a Temple University employee says the actor drugged and sexually assaulted her. Joining me are Stephanie Soriano, former prosecutor, now criminal and civil rights attorney and principal at Soriano and Associates. Nice to see you again.
Nice to see you.
Jack Cunha is a defense attorney and principal with Cunha and Holcomb. Good to see you, too. First up, Bella Bond trial. 37-year-old Michael McCarthy is charged with first-degree murder, accused of beating the 2-year-old girl to death, then dumping her body in the ocean. McCarthy, as you know, was the boyfriend of the toddler's mother, Rochelle Bond, who was charged as an accessory after the fact and cut a deal with prosecutors in exchange for testimony. Defense claims it was she who killed the little girl. You're a former prosecutor.
Yes.
Explain to me how you convince a jury. It's a he said, she said case for the most part. Is that not a fair statement?
It's fair to say.
Okay, so how do you convince that somebody who cut a deal so that she's going to get out of jail, and that somebody who's already admitted she lied about what happened after the kid was killed, how does a jury ever believe beyond a reasonable doubt that she's telling enough of the truth to send a guy away for life?
Because we know he was there, so we know that they were together.
She was there, too.
Yep, and I think what we have to see here is that not only is she a part of it, but that he was too. So I think if they can prove that, which is showing that she's just a vile person, she was there, she knew it, I think they're going to believe half of what she says and half of what she doesn't, that she was there, that she had something to do with it, and that he absolutely had something to do with it.
But wait a second, if they believe half and half, as Stephanie just said, Chuck, so then she goes home to live a life, and he goes to the can for the rest of his life. Is a jury going to be willing to do that?
She's getting probation. It's not just that she's going home. I mean, this is literally a slap on the wrist.
And the jury's going to know this, correct?
Yes. Absolutely. They'll know it. I mean, the Jonathan Shapiro, who represents him, is a terrific lawyer, and he'll do a great job. I think that what the government has going for them with her is that she's the mother. On the other hand, she admits that she disposed of her child's body. And
she admitted she lied because she was scared, basically to protect herself after that. She has said that pretty much so far. And she cut a deal. I mean, talk about an incentive to lie, which is, I assume, what Jonathan Shapiro is going to say.
She's also testified, so far as I understand it, that she didn't believe this child was possessed by demons. And then the very next witness got up and said that she also believed it. So it's a difficult case for the government.
Very quickly, what are you looking for in the next couple of days or week that will give you some indication, both of you quickly, about which direction this thing has gone?
Definitely the cross of her by the defense. It's like Attorney Cunha just said, this is something that's going to rely on the defense cross-examination and making her out to be a liar, thereby, exonerating.
You in the same place?
Yeah, I am. The other thing I think that's difficult for the defense is that it's a child. I mean, everybody's sympathies are with this child. So,
and nobody's sympathies are with either of these people.
Absolutely.
Okay. Jury selection was supposed to start today for Michelle Carter, but this morning she decided on a bench trial. That means a judge, not a jury, will ultimately decide the case. The now 19-year-old Carter is charged with involuntary manslaughter. She's accused of persuading 18-year-old Conrad Roy to kill himself in a series of texts and phone calls 3 years ago. Roy ultimately died from carbon monoxide poisoning after he connected a generator to his truck's exhaust following a phone call with Carter in which she told him to get back in the truck after he began to express doubts about his plan. By the way, none of this is disputed. The text we have, I'm going to read one in a minute. The phone call's not disputed. She waived her right to a jury trial. Why? What's the thinking?
In my opinion, that usually is because it's more of a legal issue, and you want to leave that in the hands of a judge instead of a jury. When you have a jury, they're looking at, do they like the person, do they not? They're looking at things like that. A judge is strictly going to look at the law, and it's clearly showing that the defense believes that the Commonwealth cannot rise to the level of what they believe is being able to convict her on this.
You mean because they want to make the case that words can't ever equal involuntary manslaughter? Is that what the defense argument's going to be in this case?
I believe it's that, and whether or not you could say that her words could have led him to do what he did, and not her to be convicted for that.
That may be part of it. It seems to me that the rationale, I have no idea, for saying a judge, this is a sadistic, sick young woman. I don't think anybody's going to disagree with that, including her lawyer. an emotional reaction to her, it seems to be, would be more severe from a jury than it would probably be from a judge. Is that
my
not a fair
first
statement?
reaction was a jury is going to judge her.
He's going to hate her
in a way that that a judge is not, because a judge is going to be more dispassionate. There is also the legal issue, and I think that that's the predominant reason.
Which, whether words can constitute involuntary manslaughter?
No, whether she caused his death. And this is somebody who had a long history of suicide and suicide ideation. So can they prove? And that's a legal and a factual question that's tied together.
Let me just read. I'm sure most of you have heard some of these grotesque texts. I'm starting in the middle of one from Carter to him. You're ready and prepared. All you have to do is turn the generator on. You'll be free and happy. No more pushing off. No more waiting. Roy says, you're right. Carter says in text, if you want it as bad as you say you do, it's time to do it today. Roy, yup, no more waiting. And Carter concludes by saying, okay, I'm serious. Like you can't even wait till tonight. You have to do it when you get back from your walk. Is there another case you know of? I mean, by the way, I'm not, this is disgusting. I mean, the woman has a real serious problem, even if she's acquitted. Do you know of another case where someone has been found criminally liable for causing someone's death based upon words as opposed to actions? I don't. Do you?
I think this is the first where it's actually gone to the level of an indictment and going to trial. This is clearly an assisted. This could rise to the level of assisted suicide, but in Massachusetts we don't have that as a crime. So maybe this is the prosecution saying, look, our hands are tied, so maybe it's time to create some laws that actually fit this crime. This one just doesn't.
Do you know of anything like this?
No, I mean, think about it. This is akin to somebody seeing a guy out on a ledge. And
saying jump.
They say jump.
Right.
All right? And that's a disgusting thing to do.
The only difference is she was relentless. It wasn't like jump one time.
Yes,
she was relentless.
There were other emails in which she said that she was trying to push him because she said that he needed help, and she thought that if she pushed him, he'd be more likely to get help. But to answer your question specifically, this is unique as far as I know.
One of a kind.
Yeah.
Let's go to the highest profile, probably of the three, at least nationally. The man known to millions as America's Dad begins his trial today in Norristown, Pennsylvania. Jury was pulled from the Pittsburgh area after Cosby's defense argued local jurors were exposed to too much pretrial publicity. As you probably know, he's charged with 3 felony counts of aggravated indecent assault, accused of drugging and sexually assaulting Andrea Constant, who's a former Temple University employee. 13 years ago, Cosby, 79, maintains the sexual contact was consensual. In all, more than 50 women made claims that Cosby had unwanted sexual contact with them. This is the only criminal case that has come so far from these allegations. The defense wanted, the prosecution wanted to call 12 women who alleged
13.
they'd been sexually, was it 13?
Yeah.
Only 1 was allowed. How does the judge decide 1's okay, but 4 aren't okay, and 13 aren't okay?
Well, I know you know. This is the theory. It's called prior bad acts. And generally speaking, you cannot put in evidence of somebody's bad character. So you can't show that they have a propensity to commit a crime. So ordinarily this doesn't come in unless it goes to some issue, like intent. And so the notion is that this is a signature crime, and therefore it is, you can have 1, but if you have more than 1, it's way too prejudicial. So that's the idea.
I understand the prejudicial thing, but it seems to me you open the door, you open the door. You can either have prior people testify, but 1 allows a juror to say, well, there were 2 aberrational moments, when there are dozens and dozens of women. If you're going to open the door, you open the door. No or no?
No, I think they're charging him with the crime against this particular woman. So if you bring in 13 others, then it's hard to excuse all 13. So it becomes it outweighs the probative value. It just becomes overly prejudicial because someone says, well, if they did it that many times, they must have done it here.
Would you have said that when you were a prosecutor?
No, I would have said
Okay,
that
fine.
I would have said that this is his
so.
scheme, almost the way he does a routine, essentially.
One last thing. His daughter, her name is Ensa, said this was a public lynching, saying this is all about racism. His lawyers also contended the exclusion of some blacks from the jury, the only 2 blacks on the ultimate jury, was about racism. There's no vehicle for his lawyers to get issues of racism before this jury,
I don't think it's a vehicle they would use. I think it's an actual thing that's happening here when you deal with potentially the way that this country views how certain people are gone after.
How do
per
they
se.
communicate that to a jury?
I think you'd have to communicate the fact that it took this many years to bring the indictment. I think it was 10 or 12 years.
And would
the
a judge
fact that it
allow
was-
them to say the only reason they
Oh,
only
abs-
brought us because he's a black guy?
No, what you would say is you waited. Well, in that situation, I think what you have is you have a split similar to like an OJ case, for example, where there are still many people in communities of color who believe that this is not only a public lynching, but once again trying to bring down somebody who is revered in communities of color as, you know, a great person. And I think that's what splits. And if you can get a couple people in the jury to understand that public lynching does happen, that people are targeted, that this stuff does occur, then you can get a mistrial.
I only have 15 seconds for you. Is there a way to get anything like that into a juror's
I think it's going to
mind?
be very difficult. One of the things that's very curious to me is that the other alleged victim is actually a woman of color.
Yeah.
So the prosecution, I think, is sensitive to this, and it doesn't seem to me any accident that they chose a woman of color to be their one additional victim.
Prosecuting attorney is also a woman of color, I should say, in this case. Stephanie, it's great to see you.
Thank you. You too.
Thanks so much, Jack. Good to see you as
Good
well.
to see you.
Thank you. Appreciate your time.